filing the wrong type of VA claim could delay your benefits or get you denied. In this video, I'm breaking down the top 5 types of VA disability claims, what they are, when to use them, and which one might be right for your situation. I'm Mr. X, and this is the VA Top 5. All right, kicking it off here. Claim type number 1, direct service connection. When you file your Form 526 with your claim on it, listing your disabilities, if it's your very first claim, that's called your original claim. Okay, any other subsequent claim afterwards, which is going to be a new claim, and it's filed on the same form. Now, understand that when you file a claim for direct service connection, it's either within a year after service, so it's very recent. But what you're essentially telling the VA is, hey, I have a disability, let's say for your right knee. That right knee, you can find evidence of treatment for that right knee condition in my service treatment records. That's essentially what you're telling them when you file a claim for direct service connection. It is absolutely directed to this point in service. Your right knee condition, it was injured during this period of service. If you filed a claim for direct service connection for something, let's say your left knee, that wasn't related to any treatment in service, you weren't seen, you didn't hurt it in service, if you file a claim for your left knee and there's nothing in your service treatment records that showed that you were seen for treatment, that's the quickest, easiest way to get the denial. Okay? So understand, direct service connection, what you're saying is, I had this disability, current diagnosed disability, that is directly related to this point in my service. A point you can pinpoint, point your finger at that shows I was seen in service for this issue on this date. Okay? Now, I know that seems really basic, but quickest, easiest way to explain it is like that. They're directly pointing that you have this current disability pointed towards that period in service. Okay? Direct service connection. All right, claim type number 2, secondary service connection. So, for this type of claim type, you can file it on the same 526 form. You're saying that, for example, your left knee is related to your right knee. Now, if you're claiming it's secondary towards another condition, that primary condition has to be service-connected. Or you have to be filing a claim for that at that same time. Now, some of these disabilities, if they're within the scope that the VA already concedes are related, then if they're diagnosed on the exam, then they will just grant service connection. For example, let's say you were diagnosed with diabetes mellitus. And if a part of that process, the examiner then says, hey, you have diabetic peripheral neuropathy of the right lower extremity. At that point, you don't need to file a claim for that right lower extremity peripheral neuropathy. The VA reader, while looking at the exam, is going to see that and then grant service connection. So it'll be secondary to the diabetes mellitus. Now, there's many, many secondary conditions that could be related towards one another. But let me highlight something. They have to be causally related, meaning that if it weren't for the primary condition, your secondary condition would not exist. Okay, you have to be able to prove that. We'll go back to the right knee. Let's say you're service connected for your right knee. And because you're favoring your right knee so much, because of the pain and treatment and all that, then your left knee, you're going to naturally lean to the left, use your left leg more. If that then causes a left knee problem because you're favoring your right knee so much, then that might be a scenario where you put in for service connection for your left knee as secondary to your right service-connected knee. Okay? So it has to be causally related. If you submit something or if your examiner says that, hey, these could be related, okay, and I'm putting the could in between the bunny quotes there, okay, quotations. If they only could be related, that's not enough. They have to be causally related. If it weren't for the primary condition, the secondary one would not exist. So, there's many other types that you can go through. And the one good thing for you on this is this. When it comes to things like sleep apnea, migraine, sinus issues, rhinitis, there's plenty of medical journal entries, written articles, evidence that you can submit as part of your claim and claim it as, migraines secondary to tinnitus, migraine secondary to a cervical spine condition. Okay? Now, if you're service connected for, let's say, 5 conditions, what I would do, go to your favorite browser, go to ChatGPT, and ask it, type it in, hey, what conditions are related to, and then insert one of those 5 conditions you're service connected for. And it'll give you a history. It'll give you a bunch of information about what conditions could be related to your current disability. Okay? Review that list. If you have any of those conditions, now, can't fake it. Okay, I want you to be 100% honest. But if you have any of those conditions, let's submit a claim for it. Worst thing they can do is tell you no. But you may get service connected for it. All right, claim put at number 3, presumptive service connection. Okay, now, presumptive tends to seem awfully similar to direct, but it's slightly different. Okay, at 38 CFR 3.309, there's a list of disabilities that the VA already concedes as due to service. So at the top of 38 CFR 3.309, it explains that, hey, if you have, and it lists about 20 different conditions, if you have any of these conditions within a year after service, then you can be granted service connection on a presumptive basis. Now, you may have heard of presumptive due to Agent Orange exposure or due to service in Southwest Asia. Okay, the end of 38 CFR 3.309, it talks about the conditions that are related to service in the Republic of Vietnam or Thailand or Guam. Okay, this is your ischemic heart disease, diabetes mellitus, bladder cancer, prostate cancer, lung cancer. And those are all related to service and herbicide exposure. Now, as far as service in Southwest Asia, so if you're in Iraq or Afghanistan, Kuwait, Saudi Arabia, you're going to look at 38 CFR 3.317 and 38 CFR 3.320. Okay, lists and the PACT Act. And the PACT Act added a bunch more conditions that are presumptively related to service in those areas. For example, so if you served in Iraq, doesn't matter what period of time, if the VA has record that you served in Iraq and now you have sinusitis, you have rhinitis, you have a diagnosed case of asthma, okay? Get any of those. Now, there's a whole list of them there. But since it's already conceded that those disabilities are related to service in Iraq, okay, then it's going to be service connected. The VA already provided the nexus between the two. So the presumptive is essentially the nexus, which is sometimes the hardest thing to prove. So, with presumptive, you think about those 3 things. You got to have your in-service event, and have a nexus, and you got to have a current disability. And under presumptive service connection, you already have the nexus because, it's already proven that, hey, these 2 conditions are related. So your service in Southwest Asia is your in-service event. Your service in Iraq is number 1. Number 2, the nexus is, hey, VA has already conceded that these are related. So that's number 2. So all you need to have is a current disability. Okay? So that is what makes presumptive service connection sometimes the easiest thing to win. All right, claim type number 4, aggravation of a pre-existing condition. So, where this is most often seen is on your service entrance exam. Okay, the MEV examination, they'll check your eyes out, your hearing, go through your medical history. Oftentimes, the condition that was listed the most is pes planus, or flat feet. The examiner may indicate that it was symptomatic or asymptomatic, but a diagnosis of that prior means that if you file a direct claim of service connection for your pes planus and you're receiving in-service for your pes planus, now they're not going to grant service connection on a direct basis because this condition existed prior to service. Now, if you were seen extensively in service for your feet because you're on your feet all the time doing walk marches, long 50-mile walks, and your feet hurt a lot more because of it, then what's going to happen is they're going to send it to a VA examiner to provide an aggravation opinion, basically saying, hey, the veteran had this condition prior to service. They were seen in service for this condition, the same condition. They're going to ask the examiner, did service aggravate this condition that existed prior? And it's kind of like a 50-50 at this point. Sometimes they come back and say that they're related, sometimes they don't. Depends on how extensive it is, what type of examiner that you have. Okay, this part can be a little bit frustrating, but oftentimes pes planus is one that's seen often, many times before. Mental health can be before. Those are the ones that are seen most often. I mean, if you injured your shoulder, your knee, your back, and like a high school football injury, then that may be part of your record. Now, my suggestion is look at your service treatment records. You can get a copy of your enlistment exam, and it'll show you what the doctor put. Okay, so just look at those records and know that if you submit a claim for, let's say, pes planus, and your entrance exam showed that it existed prior to service, then you're going to want to make sure that you file an aggravation type claim. That just basically means that they're going to request an extra opinion. Not doing so could slow down your claim by a month or two. If by the time the VA either looks at it, it sees that it's an aggravation thing, that they're going to defer it off for that same opinion, and it's going to be an extra month. So save yourself the time. If you know that it existed prior, the condition existed prior, just claim it as such. You're not hiding anything. You're not being secretive. But I would just be straightforward with it. That way there's no delays on the VA adjudicating your claim. All right. Claim type number 5, miscellaneous. Miscellaneous could be any number of things. They're filed on a number of different forms. So we talked about a claim for increase. That was obvious. Okay, it's just going to be filed on the 526. If you're filing a claim for individual unemployability or TEIU, that's going to be on a form VA 21-8940. If you're filing a claim for special monthly compensation for aid and attendance for housebound, special monthly compensation, that's going to be on a 2680. And you can submit it just on a 526. Special housing adaptation and special adaptation housing, that's kind of a different one. Some of these have some really strict requirements that you absolutely have to have for them to grant the SHA and the SAH. There has to be the absolute need. Generally, it's going to be a loss of use of both of your extremities or blindness or something quite serious. Okay, so get with an attorney, get with a VSO, do some homework. I'll tell you exactly what claim you should file for any of these. Okay. All right, wrapping it up here. And if you stuck with me this far, you're going to be glad that you did, okay? So I'm going to give you a huge tip here. Why it matters on what claim type you file. Why it matters so much. One, it's a speed issue, okay? How quickly the VA knows that you're filing a direct or a presumptive or an aggravation. It can speed up the time in which it takes the VA to adjudicate your claim. The other important thing, this is what really could cost you, has to do with the effective date assigned if service connection is granted. Now, with most of these, right off the top, if you file an intent to file, Form VA 21-0966 intent to file. What that does is if you file one of those, and then as long as you submit a complete claim within a year, its service connection is granted for any of the conditions you file a claim for, then the effective date assigned will most likely be the date of the intent to file. So, if you submit something 11 months ago, and you go from a 0 to a 50, then you're going to get back paid for 50% for each month in between, for 11, 12 months. So that can be like a huge little saving. Could be a huge number coming your way. Now, if you're already service connected for, let's say, your right knee condition, and you file that 0995 supplemental claim, and you say, hey, there's an evaluation issue, this should be a lot worse. Well, based on the effective date rules regarding supplemental claims, that if an increase is granted and that claim was received within 1 year, then the effective date assigned is going to be the date entitlement arose, or the date of claim, whichever is later. Now, if it was filed within a year, it may go back to the original date, as long as you can prove that you met the criteria for the higher percentage from that first date. Here's an extra tip, though. If you file that same type of claim, it's a supplemental claim for your right knee saying that your evaluation should have been rated higher, and they order a new exam. Let's say the first exam, showed that a 10% evaluation was warranted. You submit a supplemental claim, say, nope, it should be higher. If they send you for another exam, and then on that second exam, if it shows that let's say your knee is now at a 20%, well, you're not going to get that 20% going all the way back to the first date. Okay, because on that first exam, it didn't show you were entitled to a 20% evaluation. Now I know what you're thinking, well, Mr. X will just be the date of claim. Well, wrong. Under the supplemental claim effective date rules, it won't be the date of claim of your supplemental claim. It's going to be the date entitlement arose, which is going to be the date of the exam, which could be 3, 6, 8, 9 months later. In that instance, it would have been better to file just a claim for increase, because at least it would have been the date of claim, which might have been a month or 2 or 3 sooner. If you had an intent to file, that would have been better on top of that. So, there's lots of effective date rules for each different type of claim. There might be liberalizing law with some of these conditions with presumptive conditions. Okay, so you have to be aware of all of this and file the right claim, or else you could be shooting yourself in the foot with these effective date rules that could be assigned. Okay, I know it's a lot of information. Okay, and I know a lot of it's going to come down to the specifics of your file. And every one of you is different. Everyone, veterans, male, female, depending on where you served, depending on what's in your file exactly. Okay? There's no one-size-fits-all approach to all of this. That's why sometimes I feel bad to the VA rater, because they got to go through all of this and then hope they get it right in the end. Because if they don't, then we're absolutely got to let them know, right? So, the easier you can make it on them, the cleaner, file the right claim type, the easier you're going to make it on them and on yourself. In the end, if you have a question about how an effective date may come into play with your claim type that you're filing, leave me a comment. Tell me about, questions or concerns that you have, and I'll answer it for you. Okay? I'll do my best to give you the cleanest answer I can. All right. Please like and subscribe. Leave a comment about what you thought, what you would like us to address in the future. I'm Mr. X, and this is the VA Top 5.